Hello everyone, welcome to Law Junction. So I'm very much thankful to Sanjay and his team members who called me for this short video tutorial. So in this video lecture, in this tutorial, I am going to discuss the doctrine of basic structure and few case laws related to doctrine of basic structure. So just be with me in the class for the next few minutes. So let's start the class. So I will start with the story of independence movement. So when India was fighting for its independence, then our founding fathers, right from Gandhi, Nehru, Patel, they all promised a famous slogan that is land to landless. So after India got independence, then India became one of the few countries which passed series of legislation in the area of land reforms. And during that time, right after independence, the property, the land was a fundamental right. And since it was a fundamental right, and so the any violation of right to property, that is the property that means land, was challenged in Supreme Court under Article 32 and also in High Court under Article 226. And so to stop this hurdle, Nehru government, the first government of India, it passed the first Constitutional Amendment Act 1951. And this Amendment Act introduced ninth schedule in our Indian Constitution. Now, what was the purpose of ninth schedule? The purpose of ninth schedule was to make all the Land Reforms Act, all the legislation immune from any kind of judicial scrutiny. And since it was made immune from any kind of judicial scrutiny, the First Amendment Act was challenged in Supreme Court of India in Shankri Prasad case 1951. Now, in Shankri Prasad case 1951, Supreme Court had to deal with Article 13 and Article 368. So let us first understand what is Article 13 and what is Article 368. So Article 13 says that when the Parliament of India will pass any kind of law, and if that law violates any of the fundamental right or abridges any of the fundamental right, then that law will be declared nullified, void, and ultra vires by Supreme Court of India. And as per Article 368, the Parliament has the power to go for amendment of Indian Constitution. So Supreme Court in this Shankri Prasad case 1951 said that this First Amendment Act, that is ninth schedule, is within the power of Parliament by using Article 368 and not Article 13. That is the power of Constitution, the power of Parliament to amend Constitution is different from the ordinary laws. And so this act, that is First Amendment Act, is justified and it will not be void or nullified. After this the case again emerged in the Supreme Court in Golaknath case 1967. So before Golaknath case 1967, what is the scene? The scene is that the Parliament, by using Article 368, can amend even the fundamental right. Okay. So in Golaknath case 1967, Supreme Court reversed its judgment of Shankri Prasad case. And what now Supreme Court says that Constitutional Amendment Act is also a law within the definition of Article 13. And since Constitutional Amendment Act is also a law within Article 13, so we cannot amend the fundamental right, we cannot violate fundamental right, we cannot abridge fundamental right, even by using Constitutional Amendment Acts. Okay, so the thing is clear now. So since the Supreme Court of India reversed its earlier judgment in Shankri Prasad case, the Parliament reacted to Supreme Court and Parliament came with 24th Constitutional Amendment Act 1971. And in this 24th Amendment Act, the Parliament of India amended Article 13 also and Article 368 also. And now the Article 13 has one provision, and that provision says that the Parliament of India, by using Article 368, can make amendment to the fundamental rights. Okay, is it clear? So Parliament reacted towards which case? Towards Golaknath case of 1967. So again, the case came to Supreme Court of India in Keshav Nanda Bharati case. Now, Supreme Court of India in Keshav Nanda Bharati case said that whatever the Parliament did in 24th Constitutional Amendment Act, that's okay, that's fine, that's perfect. We have no issue. But in Keshavananda Bharati case, Supreme Court of India said that though the parliament has the power within this article 368 to make amendment even in the fundamental right, but the parliament is not having unlimited power, and parliament cannot abridge the basic structure of Indian constitution. That means there are some structure in our Indian constitution which cannot be altered even by using article 368. So in this Keshavananda Bharati case, the Supreme Court of India became one of the most powerful courts of India. And in fact, some scholars believe that the Supreme Court of India appeared even more powerful in comparison to the Supreme Court of America, US, because in Keshavananda Bharati case, the Supreme Court kept this basic structure doctrine open-ended. It means that during Keshavananda Bharati case, Supreme Court said that some features like separation of power, then democracy, then parliamentary democracy. These features are basic structure of Indian constitution, but this is an open-ended case, and the list of this basic structure will depend on case to case. So since by this Keshavananda Bharati case, Supreme Court of India became extremely powerful and it established the doctrine of basic structure. So this case again emerged in the Supreme Court of India in Indira Gandhi case 1975. So during Indira Gandhi case in 1975, what happened? The victory of Indira Gandhi, our Prime Minister of India, it was challenged in the court, and so Indira Gandhi government came with 39th Constitutional Amendment Act, and this 39th Constitutional Amendment Act of 1975, it tried to immune the election dispute of Prime Minister from any kind of judicial scrutiny. And so Supreme Court of India applied this Keshavananda Bharati case, that is doctrine of basic structure, for the first time in our country in Indira Gandhi case. And Supreme Court of India said that the power of judicial review is a basic structure of Indian constitution, and parliament cannot take this right of Supreme Court. And so this 39th Constitutional Amendment Act, which made the election dispute of Prime Minister immune from the judicial review, is null and void. So again, Parliament of India reacted in 42nd Constitutional Amendment Act 1976. And in this 46th Constitutional Amendment Act, the Parliament said that by using Article 368, Indian Parliament can go for amendment of any provision of our Indian Constitution, and it can amend any provision of the fundamental right. So by 46th Amendment Act, the Parliament tried to get enormous power, absolute power in case as regard to the amendment in Indian Constitution. So again, this case came to Supreme Court in Minerva Mills case 1980. So in Minerva Mills case 1980, Supreme Court reaffirmed the basic structural doctrine. And again, Supreme Court of India said that we will go for judicial review of any act of the parliament if we believe that that act violates basic structure of Indian Constitution. Again, in Vaman Rao case 1981, Supreme Court of India again reaffirmed the concept of basic structure, and Supreme Court of India said that the date that is April 24th, 1973, when the famous Keshavananda Bharati case was delivered. So the doctrine of basic structure will be applicable in all the cases after April 24th, 1973. So we can see that the Supreme Court of India in all cases, in series of cases after this Keshavananda Bharati case, reaffirmed the concept of the doctrine of basic structure. In S.R. Bomai case 1994, Supreme Court of India again said that federalism, secularism, and democracy is the basic structure of Indian Constitution. In I.R. Coelho case, which is also known as Ninth Schedule case, in 2007, Supreme Court again said that the Ninth Schedule, which attempted to make some legislation immune from the judicial review, is also not correct, and Supreme Court of India can go for judicial review of any acts or legislation, even if that is within that Ninth Schedule. So I hope I am very clear up to this. Thank you very much. Thank you. Hello everyone, welcome to Law Junction. So I'm very much thankful to Sanjay and his team members who called me for this short video tutorial. So in this video lecture, in this tutorial, I am going to discuss the doctrine of basic structure and few case laws related to doctrine of basic structure. So just be with me in the class for the next few minutes. So let's start the class.